Okay, the state versus Henry J. Killian, 22 CR 203. Are you Henry Killian appearing from the jail there with your attorney, Mr. Wagner?
Yes, sir.
All right. Mr. Killian is charged in a 6-count indictment with second-degree felonies of aggravated trafficking, aggravated possession of methamphetamine. This matter was set for plea, and we had a logistical problem Friday, and so it was Thursday, I guess it was, we rescheduled until today and had Mr. Killian brought down to Highland County. I have received a plea of guilty form, Mr. Killian, which indicates you're going to withdraw your plea of not guilty in counts 1 and 3 as amended to make those third-degree felony instead of a second-degree felony. I'm going to hand this, put this up here to the camera and show you. And do you recognize this form that has your name and the plea of guilty and case number?
Yes, sir.
All right, and then on page 3, about halfway down the page, the last sentence reads, "I enter this plea voluntarily." Immediately below that is a signature, appears to be Henry Killian. Is that your finger there next to that X?
Yes, sir.
And when did you sign this document, Mr. Killian?
Last week.
All right, and did you go over this with your attorney before you signed it?
Yes, sir.
Okay, was that up at the Fayette County Jail?
Yes, sir.
And you, did you understand when you signed it there was an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
Did you sign this document voluntarily?
Yes, sir.
And are you still wanting to go forward and plead guilty voluntarily?
Yes, sir.
All right, now, the document, as I indicated, you're currently charged with second-degree felonies, which carry a mandatory prison term of at least 2 years up to 8 years set by the judge, with the possibility of it being extended by up to 50% by the parole authority, or by the Department of Rehabilitation and Corrections. Now, it looks like they're reducing this by 1 degree to a third-degree felony in each count. It's the same section number, but it's reduced by 1 degree by deleting, I believe, the allegation of reducing the allegation of the amount involved. Now, it indicates you understand that that amended charge would be third-degree felony in each count. It would have a maximum possible prison term of 36 months on each count. There'd be a minimum of 9 months prison that's available, and then there are certain levels in between those two ranges. There's a fine of up to $10,000 as possible, mandatory fine of $5,000, possible license suspension of 6 months to 5 years. Now, as amended, the prison term is not mandatory. It's presumed, but it's not mandatory as it is in the second-degree felony. Now, you understand that?
Yes, sir.
Now, under the law, if you are sentenced to prison on both of these charges, the court could order those sentences to be served consecutively, meaning one after the other. So the maximum possible prison term on each count is 36 months, so that makes the maximum prison term possible on these two charges of 72 months in prison, fine of $20,000, mandatory fine of $10,000 total. Do you understand that?
Yes, sir.
And if you are sentenced to prison from the charges you're facing in Fayette County, those charges, that sentence could order to be served consecutively to the sentence in this case. You understand that?
Yes, sir.
You haven't been sentenced up there yet on that charge?
No, sir.
Okay. Now, are you currently on facing any other charges other than the Clinton County charge and these charges?
No, sir.
And are you currently on probation, community control, post-release control, or parole for a felony from Ohio?
No, sir.
All right, now under the law, if you're convicted of these offenses and sentenced to prison, once you complete the prison term set by the court, the Adult Parole Authority has the right, if they exercise it, it's an optional thing, to put you under post-release control for a period of up to 2 years, which means you'd be supervised by a parole officer in the terms they set. And if during that period of time they determine that you had not complied, they could return you to prison to make you serve an additional period of up to 9 months for a single violation, with a maximum of half of your prison term for all violations. However, if you commit a new felony while under post-release control, then in addition to whatever sentence a judge in the new case could impose, that judge could also sentence you for committing those violations while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence of the new case. Do you understand that?
Yes, sir.
Now, under the laws, I indicated these are not mandatory prison sentence offenses. They are presumed but not mandatory. So that means that it is possible under the law that instead of being sentenced to prison, you could be put under community control or probation, which means you'd be supervised in the term set by the court by a probation officer for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court, serve a copy on you. You would have a hearing, be entitled to be represented by an attorney at that hearing, and if the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and sentence you to prison for 72 months and fine you $20,000. Do you understand that?
Yes, sir.
All right, now, as charged in count 1, it's alleged that on or about October 5, 2021 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk but less than 50 times bulk in violation of 2925.03A1. Now, in order to reduce this to a third-degree felony, the state, I believe, is reducing that from 5 times to 50 to over bulk but less than 5 times bulk. Is that correct, Ms. Collins?
That's correct.
All right. And so that makes it a third-degree felony. And then count 3 alleges that the same thing and the same amount as reduced on October 6th. So basically, they're both the same charge, just different dates. And as amended, then, to make the amount over bulk but less than 5 times bulk, it's a third-degree felony with the penalties that I've described earlier. Now, Mr. Killian, you understand the amended charges and the possible penalties?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, legal issues in the case, of possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to get you to plead guilty here today?
No, sir.
Right now, there are 5 lines printed at the bottom of page 2 in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 1 as amended and count 3 as amended. State will dismiss remaining counts. State and defense jointly recommend 18 months incarceration on count 1, consecutive 12 months on count 3. Defendant agrees to pay back bond money to Highland County Task Force in the amount of $1,450. The defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Has anyone?
If I may, Your Honor?
Yeah, go ahead. Hey, Ben, would you go get my coffee off my desk?
We're fine, sir.
Okay. Now, has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
And under the law, Mr. Killian, the amount of the sentence is up to the judge, not the parties. And so even though there's a recommendation, you get a total of 30 months out of a possible 72 months. If you plead guilty, the court's not required to follow that recommendation. After I heard all the information that's presented to me, if I decide that's not the correct sentence, I could sentence you to any prison term between 9 and 72 months as provided by law. Do you understand that?
Yes, sir.
All right. Thank you. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
Now, you have certain constitutional rights, you must understand, before I can accept your plea. First, you have the right to have an attorney. Mr. Wagner is appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So, if you decide that you do not want to do this, he'll continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right now, under the law and the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law by the judge, and then that jury would decide by unanimous verdict, meaning all 12 of them would have to agree as to a verdict on either or both cases. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means instead of a jury hearing the evidence, it would be the judge would hear the evidence. The judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Killian, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify on your behalf if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Killian, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of the offense charged. So, the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all at your trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of each offense, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, the originally entered plea of not guilty to these charges, Mr. Killian, that plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've described for you this morning. If you change your plea from not guilty to guilty with the amended counts 1 and 3, that plea is the opposite of the not guilty plea. That plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you this morning, except your right to have an attorney, which you always have no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or court trial, to waive or give up your right to confront witnesses against you and cross-examine them through your attorney, waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state, would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence or under the certain circumstances, you could file an appeal that would have to be filed within 30 days of your sentencing entry being filed. Do you understand that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, I neglected to do this at the beginning of the hearing, but Mr. Wagner, you and your client both agreeing to this case being conducted remotely rather than your client and you being present in the courtroom physically?
Yes, sir, Your Honor. That's why I came out earlier, just to answer
Okay.
any questions for you.
All right, and you are okay with that, Mr. Killian?
Yes, sir.
Okay, thank you. Now, you have any questions about the charge or the possible penalties?
No, sir.
You understand those?
Yes, sir.
And you have any questions about the constitutional rights I've explained to you?
No, sir.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand the terms of the agreement?
Yes, sir.
All right, is there anything further you need to talk with your attorney about before we go any further?
No, sir.
Have any questions about anything I've explained here today?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the amended counts 1 and 3 pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
All right, then as amended, in count 1, that would read that on or about October 5, 2021 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in violation of Section 2925.03A1, a third-degree felony, carrying a possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 3 as amended, which reads that on or about October 6, 2021, Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, violation of Section 2925.03A1 of the Ohio Revised Code, a third-degree felony, carrying the same penalties as count 1 as amended. How do you plead?
Guilty.
All right, thank you. And for purposes of the plea and so this is clear on the face of the document when it goes with him to prison, making the changes in count 1 and 3 to third-degree felony from F2, and I'm changing exceeding bulk, or amending the agreement as stated to exceeding bulk amount but less than 5 times bulk amount in each case. And putting my initials next to those changes. All right, the court finds then on this day in open court, the defendant was made advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The pleas are accepted and ordered filed as to counts 1 and 3. Defendant is found guilty of aggravated trafficking of methamphetamine as amended in each count, a third-degree felony. All remaining counts are dismissed. Now, inasmuch as this is an agreed-upon recommended sentence, the court's not going to order a pre-sentence report, but will instead proceed with sentencing forthwith. All right, anything from the state regarding sentencing?
Only what's contained with the plea agreement, Your Honor.
All right, Mr. Wagner.
Your Honor, we asked the court to follow the recommendation of the parties. In looking at the discovery packet, I guess it would be a cursory review of my client's criminal record. I see an OBI in 2000 and a drug paraphernalia case in 2010. Again, there may be something else out there, but speaking with Henry, this is all that's out there. Obviously, Fayette County is pending. So he kind of jumped in the deep into the pool, Your Honor, so to speak, these felonies. We would ask the court to consider all that and pass the sentence here today.
What's the charge in Fayette County he's facing?
F2, Your Honor.
All right, has that been disposed yet?
No, sir.
Okay.
Ms. Hackner, the 20-year-old man, I looked up on the docket this morning, he got informal pre-trial on the 6th. I think it's jury trial date March 6th.
All right. All right, Mr. Killian, anything you would like to say?
No, sir.
All right. It is a judgment order of the court that you be and are hereby sentenced to the Correctional Reception Center in Orion, Ohio for a period of 18 months as to count 1 and a period of 12 months as to count 3. Those sentences are to be served consecutively. The court finds that those offenses were committed as part of one or more series of conduct and that the harm caused is such that one single sentence will not accurately reflect the seriousness of the conduct, and that the sentences that are imposed are not disproportionate to the harm caused, and also because of these being conducted in a relatively short period of time, that this criminal conduct indicates a need to protect the public from future crime. Also, the court finds that this was an agreed recommended sentence. According to the Sheriff's Department, Mr. Killian, you have 7 days of jail time credit. That would be just the days you were brought back. Well, it looks like October 6th to October 12th of last year, and then you've been in Fayette County since then, I guess. Okay.
Yeah.
All right. So you'll get credit for those days served. And then you'll be going back to Fayette County unless they want us to go ahead and take you, but I think they want you back. So anytime you're being held up there is going to count on that sentence, not this sentence, if you're convicted. Now, upon completion of the sentence, it is possible the Adult Parole Authority may put you under post-release control for a period of up to 2 years. They don't have to. They can. If they do, you'll be supervised by a parole officer on the terms they set. If during that period of time they determine that you have failed to comply, they can return you to prison even though you serve the entire term set by the court. for a period of up to 9 months for any single violation, up to a maximum of half of your prison term, which is 15 months for all violations. However, if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in these cases to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively the sentence in the new case. Now, it's also ordered that you pay restitution in the amount of $1,450 to Highland County Task Force, payable through the Highland County Victim Witness Escrow restitution account. You'll pay any fees that are charged for that, and that is a substantive order. It doesn't go away even if you serve your entire prison term. It'll be there until you pay it off or you die, whichever comes first. If you don't pay it off, the state could pursue that through various means, including getting liens and so forth. If that didn't get it paid, then the court could enforce that through contempt if you had the ability to pay and refused to pay. Now, there's been any change in your financial circumstances since you were arraigned on these charges? All right, then the court will find that you do not have the ability to pay the mandatory fine, nor is it likely you will have it in the near future, and therefore that is waived. You are ordered to pay the court costs, however, for which judgments grant execution is ordered, and if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't get it collected, then once you get out of prison, not while you're in prison, but once you get out, the court could order you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded back to custody then, Mr. Killian. Thank you.
I'll give you a second, Your Honor.
All right. All right, case number 22 CR 37, State of Ohio versus Heather Marie Tankersley. Are you Heather Marie Tankersley?
Yes, sir.
All right, Mr. Wagner is Ms. Tankersley's attorney. They're appearing by Zoom from the jail, representing the state. From her office is Prosecuting Attorney Collins. And Mr. Wagner, you and your client both agree to her appearance with you in this courtroom is not necessary. You can appear by video.
Yes, sir.
And you're all right with that, Ms. Tankersley?
Yes, sir.
All right, Ms. Tankersley is charged in a 6-count indictment with 3 counts of aggravated trafficking in methamphetamine and 3 counts of aggravated possession of methamphetamine. This is set for a pretrial on Wednesday, the 1st. However, the court was informed that the parties had reached an agreement, and the matter was set for plea this morning. I have received a plea of guilty form, Ms. Tankersley, which indicates you're going to plead guilty to count 1, 4th-degree felony, and count 3, or 5, I'm sorry, count 5 as amended. 3rd-degree felony. Okay. Now, I'm going to hold this up to your to the camera and ask you if you see your name and case number there and the
Yes,
plea of
sir.
guilty form. All right. And on page 3, there's a sentence about halfway down, the last sentence that says, enter this plea voluntarily, and right below that there's a signature with an X. It looks like next to the X is Heather Tankersley. Is that your signature I'm holding up there? All right. And when did you sign that, Ms. Tankersley?
Friday.
All right. And before you signed it, did you go over it with your attorney and have him explain everything to you and answer any questions?
Yes, sir.
When you signed this agreement, did you understand it was agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing.
Yes, sir.
And did you have enough time to fully consider that matter before making this decision?
Yes, sir.
And do you feel you've been rushed or pressured in any way?
No, sir.
And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
And this is still what you want to do?
Yes.
All right. Now, the the agreement says that you're going to plead guilty to count 1, aggravated traffic of methamphetamine under 2925.03A1, a fourth degree felony, and amended count 5, aggravated traffic of methamphetamine under 2925.03A1, which has charged as a third degree felony, but would be reduced to a fifth degree felony. Or I'm sorry, a third degree. It'd still be a third degree felony, but it would remove the language that's a mandatory, or that it has a prior conviction, which I believe makes it mandatory sentence, so it's not mandatory. Yeah.
That's correct.
All right. You understand that, Ms. Tankersley?
Yes, sir.
Now, it states on page 1 that you understand that this, to count 1, the maximum possible prison term is 18 months, the minimum is 6. There's a fine of up to $5,000 and a possible license suspension of 6 months to 5 years. And on count 5, as amended, there's a minimum of 9 months, a maximum of 36 months, and it goes from 9 to 12, and then every 6 months up to 36 months. There's a fine available of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. And on that count, prison term is presumed to be necessary, but it's not mandatory. You understand that?
Yes, sir.
Now, under the law, if you're convicted of both these offenses, the court could impose a prison term that would be consecutive. And so if you receive the maximum on count 1 of 18 months, the maximum on count 5 of 36 months, that would be 54 months or 4.5 years, possible fine of $15,000, and mandatory fine of $5,000. You understand that?
Yes, sir.
Now, other than these charges, are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
All right, now, under the law, if you are sentenced to prison on these offenses and serve that prison term, it is possible that the adult parole authority may, upon completion of your prison term, impose post-release control upon you. It's their option. What it means is that you could be supervised by a parole officer for a period of up to 2 years under the term set by the adult parole authority, because the judge is involved with that. If during that period of time they determine that you have failed to comply, they could return you to prison even though you served the entire term set by the court for a period of up to 9 months for any single violation, up to a maximum of half of whatever prison term was imposed for all violations. But if you committed a felony while under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively, the sentence of the new case. You understand that?
Yes, sir.
All right. Now, it's stricken out on the plea form that community control is not applicable, but it is applicable. So I'm going to explain that to you, that under the law, even though there's a presumption on count 3 that you should be sentenced to prison, it's not mandatory. And so it is possible under the law that you can get community control, which means that instead of being put under in prison, that you'd be put under supervision of a probation officer for a period of up to 5 years under the terms set by the court. And if during that period of time the probation department felt that you were not compliant, they could file a written notice of that, alleging that with the court, serve a copy upon you. There would be a hearing. You would be entitled to have an attorney to represent you. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to, let's see, what was it, 54 months, and fine you $15,000. You understand that?
Yes, sir.
I'm going to write on this that community control is applicable and was explained to defendant. And I'm putting in the possible sentences too. All right. Now, the first count alleges that on or about June 7, 2021, Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of Section 2925.03A1 of the Ohio Revised Code. That's the 4th degree felony, possible prison term between 6 and 18 months, and a fine of $5,000, and license suspension of 6 months to 5 years. Count 5, as amended, would read that on or about June 21, 2021, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. The 3rd degree felony, possible prison term between 9 and 36 months in the levels provided by law, a fine of $10,000, a mandatory fine of $5,000, and possible life suspension of 6 months to 5 years. Now, do you understand, Ms. Tankersley, what you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Now, has anyone threatened you in any way to make you plead guilty here today?
No, sir.
All right, now at the bottom of page 2, there are several lines printed in bold and underlined, which I will read as follows. Defendant shall enter a plea of guilty to count 1 and count 5 as amended by removing language regarding the previous convictions. State will dismiss remaining counts. State and defense jointly recommend 12 months incarceration on count 1, consecutive to 18 months incarceration on count 5. Defendant agrees to pay back by money to the Highland County Task Force the amount of $295. Defendant agrees to cooperate fully with the task force. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter sentence is up to the judge, not the parties. And so even though there's been an agreement that that sentence should be a total of 30 months, I'm not required to follow that. If you plead guilty, once I've heard all the information that's presented, if I decide that's not the appropriate sentence, I could sentence you to any sentence between 6 and 54 months, fine you $15,000, and suspend your license. Do you understand that?
Yes, sir.
Do you hold any certification or license from any state governmental agency that regulates any profession or occupation?
No.
Okay. Now you have certain constitutional rights, which I understand before I can accept a plea from you. First of all, you have a right to have an attorney. Mr. Wagner was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you would like him to provide. So if you decide that you do not want to plead guilty, that you want to defend against these charges, he'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yes, sir.
Right now, in each of these cases, Ms. Tankersley, you have a right to have a jury trial, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence to be presented, they'd be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree on a verdict as to each of those 2 counts. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt on either or both counts. Do you understand that?
Yes, sir.
Right now, under the Constitution, Ms. Tankersley, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, and your attorney and anyone else is present in the courtroom. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a court order. That's called a subpoena. And that would force those witnesses to come into court to testify on your behalf if you wanted them to, even though they did not want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to comment about that except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent of these charges till proven guilty by the state of Ohio on every essential element of each offense. What that means is that the burden of proof isn't on you to prove you're not guilty just because you've been accused. In fact, under the law, you don't have to present any evidence to defend yourself at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio and the prosecutor to prove your guilt by proof beyond a reasonable doubt on every essential element of each of these offenses, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now, originally, you entered a plea of not guilty to these charges. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from counts 1 and amended to count 5, from not guilty to guilty, that's the opposite of the not guilty plea. That plea would admit the allegations in the indictment as amended in count 5 and as alleged in count 1, admit that the allegations are true and that you committed those offenses. And that plea waives, gives up all the rights that I've described for you today except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you and to cross-examine for your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Would waive or give up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. Would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely to happen. And finally, it gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Now, are you a U.S. citizen, Ms. Tankersley?
Yes, sir.
All right, now, do you have any questions about either the charges or the possible penalties?
No, sir.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation of sentence is not binding on the court?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, sir.
You understand that?
Yes, sir.
Do you have any questions that you would like to ask your attorney about before we go any further?
No, sir.
And do you have any questions about anything I've explained to you here today?
No, sir.
And you are a U.S. citizen?
Yes, sir.
All right. Then is it your decision to withdraw your not guilty plea to count 1 and to amended count 5 and to plead guilty to those charges?
Yes, sir.
All right, then as to count 1, alleges that on or about June 7, 2021, Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in amount equal to, in violation of Section 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, a 4th-degree felony, carrying possible prison term between 6 and 18 months, a fine of up to $5,000, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to amended count 5, which alleges that on or about June 21, 2021, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. Also a charge of aggravated trafficking of methamphetamine, a 3rd-degree felony, carrying possible prison term between 9 and 36 months in increments provided by law, a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this day in open court, defendant was advised of all of her constitutional rights, made an only intelligent voluntary waiver of the same pursuant to criminal 11. Pleas accepted and order filed. Defendant is found guilty of count 1 and amended count 5 as recited in the agreement. And to comply to make sure that these match up with the entry, the court has deleted the allegation of the prior conviction in count 5 and initialed that. All right. The remaining counts are dismissed. All right. Then, as much as this is an agreed sentence recommendation, defendant has previous history known to the court and is reflected in the file. The court's not going to order a pre-sentence investigation and will proceed with sentencing forthwith. All right, Ms. Collins, on behalf of the state.
Only what's contained within the plea agreement, Your Honor.
Okay. Mr. Wagner, Ben.
I apologize, sir.
No, go ahead.
Your Honor, we would ask the court to follow the recommendation of the parties. Obviously, the court is aware through the amendment of the prior conviction being deleted and prior issue to the court. We're well aware that we give the court some caution on this recommendation. This case is moving forward with no undue delays, Your Honor. Just a hair outside 30 days from her arraignment. We were able to go through the discovery, view the video. As soon as we got halfway through the discovery, Heather was done. She said, "Get me a plea, let's get this case over with." With that being said, Your Honor, we'd ask the court to follow the recommendation.
All right, Ms. Tankersley, is there anything you'd like to say?
No, Your Honor.
All right, then is the judgment of the court that as to count 1, you be sentenced to a term of 12 months at the Ohio State Reformatory for Women in Marysville, Ohio, and on count 5, also to the Ohio State Reformatory for Women, a sentence of 18 months. Those sentences are ordered to be served consecutively for a total of 30 months. The court finds that these offenses were committed as part of more than one course of conduct, and that one single prison term not adequately reflect the seriousness of the offense. And the sentences that are being imposed are not disproportionate to the harm caused. The court also finds that it's an agreed sentence recommendation, and that the defendant's prior criminal history, which I believe is about 6 previous felony convictions, that a consecutive sentence is necessary to protect the public from future crime by this offender. According to the Sheriff's Department, I believe you were arrested on December 18th, is that correct?
Yes, sir.
So that would be 46 days. Well, actually, as of Wednesday, it would have been 46. So today it would be 44. Now, upon completion of this prison term, Ms. Tankersley, the Adult Parole Authority may exercise the option to put you under post-release control for a period of up to 2 years. If they do, you'll be supervised on the terms they set, and if during that period of time they determine that you should be under post-release control, they can do that. It's optional, but it's up to them. If they do, you'll be supervised on the terms they set by a parole officer, and if during that period of time it's determined that you have failed to comply, they can return you to prison and make you serve an additional period of 9 months for any single violation, up to a maximum 1/2 of your prison term, which would be a total of 15 months, half of 30, for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in that new case can impose upon you, that judge could also sentence you to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. Now, you're also ordered to pay the court costs which judgment, grant, and execution is ordered, and if you fail to do that or make payment arrangements, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could order you to do community service and give you credit for each hour you work and an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. You're also ordered to pay the amount of $295 in restitution to the Highland County Task Force through the Highland County Victim Witness Restitution escrow account and pay any fees associated with that. And that is a substantive order which will be in place and can't be discharged by serving your time or by bankruptcy, you have to pay it. Now, has there been any financial changes in your since you've had Mr. Wagner appointed to represent you?
No, sir.
All right, then the court will find that you're not able to pay the mandatory fine in count 5, and that there's no likelihood you'll be able to pay it in the near future, and so that fine is waived, and there will be no license suspension. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, you'll remain in custody, Ms. Tankersley.
Yes, sir.
Judge, Mr. Wagner and I have court downstairs right after this, so I'll
Okay.
have him sign the entries and that, I'll bring him up.
Okay, that's fine.
Is
All
there
right.
more in jail over this, Your Honor?
We're going to do an arraignment, so if you tell the deputy to bring in Mr. Holt.
Yes, sir.
All right, are you Christopher Ernest Holt?
Yes.
Okay, this is case number 22 CR 243, State of Ohio versus Christopher Ernest Holt. Mr. Holt's appearing by Zoom in the jail. Mr. Holt, you were indicted by the grand jury on December the 6th of last year, charged of aggravated possession of methamphetamine, alleging that on or about June 11th of last year, in this county, you had knowingly obtained, possessed, or used methamphetamine. Now, that is a 5th-degree felony. It carries a possible prison term if convicted between 6 and 12 months and a fine of $2,500. There's also a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you. If you can't afford to hire one, the court will appoint one for you. I see that you filled out a financial disclosure form. Is everything in this form correct?
Yes, sir.
And when was the last time you were employed?
Probably 5 months ago.
Okay. All right, the court then will find that you are entitled to appointed counsel, appointed attorney with William Armentrout to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. We will set your first pretrial for February the 15th at 2:15 p.m. Final pretrial will be March the 8th at 2:15 p.m. Trial date will be March the 23rd at 8 o'clock a.m. And I see you don't have any previous convictions, is that felony convictions, is that correct?
Yes, I got a couple previous.
Oh, you do? What for?
I have two prison numbers.
All right. And when did you get out of prison the last time?
I've been out a little over a year now.
All right. What county were those convictions from?
The last one was Fayette County.
All right. Well, I see there was a summons issued for you, and you, at the time, they had you listed as living in Springfield. But you've been staying in Greenfield then with your father, I see?
Yeah, I moved to Greenfield.
All right. Well, I'm going to release you on your own recognizance, which is your promise to appear. But if you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll be required to pay a service fee of $171 for the statutorily required fees. Make payment arrangements with the clerk when you get out. You'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them immediately upon release. You report once a week for 4 weeks, and then after that, as they determine, undergo random drug testing and may order, provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. When any treatment's indicated, you enroll in and follow that during the pendency of this action. You'll also be under house arrest. At your residence is at 706 South 2nd?
Yes.
All right, at 706 South 2nd Street in Greenfield, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can attend any kind of job training, educational programming, college classes, GED, etc., and you can attend church services. Other than that, you have to be there at all times, and if you fail to comply, then the court could revoke that bond and have you held till further order of the court. Now, we will notify Mr. Armentrout of his appointment. You can also get his phone number there at the jail, and then should make contact with him so you can discuss your case before your first pretrial. So as soon as you get done, you're going to go to the probation office uptown. You know where that is, across from the Flagway station?
Yes.
All right. Have any questions?
Your Honor?
Yes.
He's actually sentenced out of county court for 180 days.
Oh, okay. Well, then it doesn't matter. All right. Okay. All right. Thank you.